Alex here with part 169 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go into the response that we filed to my ex's objection to notice of compliance. Just in case anybody was wondering why I didn't go through that parenting plan line by line, I'm going to wait until an order is entered on that, and at that point in time we can go through it, because we are going to have to go through that, and I'd rather not go through it multiple times. So until the court enters its order, I'm going to hold off. Once the court enters its order, then I'll go ahead and go through that parenting plan line by line. I know a lot of people ask me a lot of questions on parenting plans and what I think about them, and I glazed through the last one because it was just a proposed one, and I knew that large portions of it weren't going to be approved anyway. So this video goes into our response to that objection. I imagine most of what I commented on in the previous, or at least the video where I went over their proposed parenting plan, is going to be addressed more thoroughly now that we actually have a filing that we entered. I think the mindset was frustrated, extremely frustrated. There's nothing like going through the agony of seeing your child suffer for 9 months, paying all this money for an attorney, going through an evidentiary hearing, winning the evidentiary hearing, and not even a few months later, your opponent's trying to act like it never happened. And their attorney just goes along with it. Yeah, let's just pretend none of this ever happened. Let's just pretend the court didn't find you to be neglectful. Let's just pretend all this. Let's just erase all of that, all that work, all that stress, all that time and money, and then let's just ask for 5 times the time the court awarded you, and just act like it's okay. Not only are we going to act like it's okay, but we're going to actually say that your ex is evil because he's giving you so little time. And that's exactly what they entered into that filing, and that's where the mindset was here. The frustration cannot be described in words. The audacity and the gall of your opponent and their attorney to just do all of those things that I just described moments ago. You have to go through something like this to really know what I'm talking about. And as I mentioned in the previous video, these efforts fail, luckily. But had they succeeded, I'm not sure what I could have done. It doesn't seem to me that the legislature has thought that this is a possibility. And I know for sure it is, not just because I went through it, but there are other people who have sent me messages who've actually suffered what I have described to you, which is somebody goes through all that work, gets everything done, and then they just get a new attorney, and a few months or a year later, they file something and act like nothing ever happened in the past and all that abuse never happened. It happens, and it does unfortunately dupe some judges. We're going to talk about this less because in my case it didn't work, but at least in the series. But if we have other points or other types of videos, or I cover other types of cases, maybe I might end up coming up. Anyway, I think we should now just go ahead and go straight into what my attorney has done. Have my attorney's response to objection to notice of compliance and request for hearing. Standard introductory paragraph. The attorney is introducing herself, indicating that she's representing me and that we are filing a response to objection to the notice of compliance. So here we have this summary of what I assume to be the facts and procedure. I reviewed my ex's proposed parenting plan and her objection, filed in response to my visitation plan outlined in the notice of compliance. Okay. My ex's primary argument is that the law prohibits the visitation plan as she claims it is vague and unenforceable. The visitation plan is not in contradiction to the law, despite her position that the visitation plan does not comply with the law, and without waiving this argument, in an attempt to reach a compromise, I prepared a compromise parenting plan that emphasizes flexibility while addressing and incorporating some of her concerns. So that's probably attached as an exhibit. We'll probably get to the, wait, isn't it? According to this, it's exhibit 1. Okay. So it should be attached to this. Anyway, let's see. I oppose mediation because it's futile. I'm requesting a settlement conference instead. Okay, yeah, and I talk about this, guys, in the video Mediation and Settlement. I explain how to deal with the problem of going to mediation with somebody who just can't mediate. So please watch that video if you haven't seen it yet. We have here, let's see, proposed visitation plan complies with the statute. So the statute says that an award of limited custody to a child has to define the right with sufficient particularity to ensure that the rights of the parties can be properly enforced and that the best interest of the child is achieved. That's all. It just has to be enforceable, guys. It doesn't have to be a 22-page document with 16,000 details. As long as it's enforceable and it serves the best interest of the child, that's good enough. And this makes sense. You don't want to make a parenting plan that says something like, the father is allowed to see the child whenever their ex says it's okay. That's an unenforceable plan because the ex can just say it's never okay. And just like that, the father can never see their child. And that's actually in compliance with the court's order because the court's order says exactly that. That's a court order that's in violation of the statute. This court order, or this proposed parenting plan, says that if my ex claims time, she gets that time. I don't get to say no. I don't get to say that's not going to work for me. Once she sends a notice saying she wants a certain amount of time, she gets that time. It's enforceable. I can be held in contempt if she allowed that order to get entered. Instead, she gets one of these long-winded parenting plans and she ends up missing out on all this time anyway. So she ends up asking for and getting what she wants only to her own detriment, which is consistent with high conflict exes. The point for them is not to actually get something that's better for them or their child. The point for them is to continue the conflict. So if by continuing the conflict, she ruins her own custodial situation, that's okay with her as long as the conflict continues. If her custodial situation is enhanced but the conflict ends, that's not okay with her. Let's move on. The law mandates that the court ensure parental rights be as enforceable as recognized in any visitation plan fashion, and there's some case law here that discusses that. This is pretty obvious. I'm not going to go through all these details. What I mentioned to you guys, I've talked about in previous videos, which is that these holidays and these breaks that she wants, she can claim. She can get those breaks. She can get them every year. The only thing that I'm allowed is a small window of time for vacations. But I mean, all the things that she's complaining she doesn't get, she actually does get if she claims them. Here we have the visitation plan considers the child's best interest. Well, the child gets to see the mother with a certain amount of time. That's the same amount of time that she had if I didn't move. Let me just stress that to you guys again. The amount of time that she gets under this plan is the same amount of time that she would get if I didn't move. The same. So it's not like what she's trying to characterize this is, now that I'm moving away, all of a sudden she gets a tiny bit of time with the child. She's basically hoping that this judge doesn't know what's going on and that this judge has forgotten the hearing. Because at that hearing, the judge gives her 52 days. So she's hoping that this judge has amnesia, completely forgets that, and thinks that I'm all of a sudden restricting her time because I've moved away. And one of the things that I stress, and I think I even mentioned it in here, let's take a closer look here. Yep, it's right down here. This is the paragraph. The limitation on the aggregate amount of time that my ex is going to get is based on the court's finding of dental neglect. And here is the court's finding. It's quoted here. And here we have the discussion on the level of conflict between the parties, the fact that it originates primarily with my ex, and that the visitation plan is limited to non-educational days due to the fact that she couldn't take him to school. So all of these are the court's findings. It's not just me inventing this notion out of thin air. This is, and I'm speaking to people who've watched the hearing video, so you guys know because you've seen the video yourselves. But she and her attorney are hoping that the judge has just got so much going on that she just won't remember who this person is or what happened. And anyway, we've talked about this enough. Let's move on. So yeah, here's the court ordering that my ex shall have every other weekend, beginning Sunday and lasting till Tuesday morning. a lot of this is just beating a dead horse. We've already gone through this. This is the next paragraph arguing that my ex was deliberately limited to every other weekend by the court. My ex was already limited to 52 days per year, and I stressed this many times. She's making it seem like this is happening because I'm moving, but if I don't move, this is her situation anyway. This is what she gets anyway. Let's move on. I'm mainly interested to get to our proposed parenting plan, the compromise. We're maintaining the 52-day argument here, and we're going through all of the dental neglect, all of the court's findings. It's like we're just having to rehash what we've already talked about. And here we go. I am trying to block modification using res judicata principles. My ex is disputing my version of a fair and reasonable plan as it extends to the court's directive, making relocation conditional based on the implementation of a new visitation plan. In essence, any hearing flowing from my ex's objection is an extension of the order granting a motion to modify child custody. This is an excellent argument. What I'm saying here is that what's going on now, this is not a brand new hearing on modification of custody. This is an extension of the prior hearing. So I've already gotten these concessions. These orders have already been entered. What my ex is going to get here is an extension of that hearing to discuss the visitation plan. I didn't even remember making this argument, guys. This is a wonderful argument because it locks the court out of magically acting like nothing from before happened, just forgetting all of that stuff and let's just enter a brand new order as if she's a wonderful mother and as if everything in this family is going fantastic. And what I'm trying to say here is no, res judicata does not allow the court to do that. And I go in and explain to the court that they should really treat this as just an extension of that prior hearing, and that's it. Not a brand new hearing, not a modification hearing, just an extension of that prior hearing. Mediation is not appropriate. So we have Rule 53, 14b subsection 1, and I talk about this in the video, mediation and settlement. This is what I use to get out of going to mediation with my ex, and it works very well. I end up never having to go to mediation with her again. Consolidation of all orders. If it's my ex's intention to consolidate the existing orders into a single parenting plan, then I'm taking this opportunity to state that I'm inclined to do that. My ex was provided notice and an opportunity to respond to the visitation plan, and she failed to do so. Well, it doesn't really matter because she's doing so now. Let's see, my ex's proposed parenting plan. I'm requesting that this judge adopt an order compliance with my compromise parenting plan attached as Exhibit 1. So we're going to take a look at that in a second. Custody arrangement. I'm opposing any modification of primary and physical custody. However, the custody arrangement as outlined, let's see here. I'm making no objections in stipulating to Section 1 of the custody arrangement with the exception of the last sentence. What am I objecting to? I object and do not stipulate that I shall have primary physical custody subject to my ex's visitation, which is outlined. I'm stipulating that my primary physical custody is subject to her visitation, but I opposed that the visitation as outlined. Okay, that's what I'm saying. So same thing. So this is what I'm agreeing and disagreeing to with regards to my ex's proposed parenting plan. So the global priority I agree to. I'm objecting to when she has the child. Guys, as I mentioned before, I'm going to spend more time on this when we actually go through the real parenting plan that's signed and entered by the judge. I'm just going to glaze through most of this, but this section here is me trying to get her visitation under control. She's trying to ask for, I don't know, 4 or 5 times the time she was offered by the court when she was found neglectful, and I'm trying to keep it down to the 52 days. Let's see, I'm stipulating to individual days. Okay, so this is the discussion on the major holidays. I guess I'm just trying to limit which holidays are considered major holidays. We're talking about the 14-day vacation period. This is the same as it's been. I'm asking for it to stay the same for the most part. There are some details on, who should deal with trips, because now, we're going to live a lot further apart. But again, let's talk about this more when the final order gets entered. Summer vacation. Again, I'm objecting because she's trying to get a tremendous amount of time despite the fact that she's been found neglectful. Sorry to glaze through so much, guys. If again, with my previous videos in my Docket series, you can always go down into the description below, click on the link, download the video for yourself, and if you have any questions, go ahead and post something down in the comments and I'll address it. But I know that we're going to end up going through this line by line when the court order gets entered anyway, and so I'm trying to save some time. Exchange location, telephone and email access, concerns regarding him having his own phone. I talk about this in the video boundaries. We'll talk about this more when the final order gets entered, but if you want a little bit of a preview on this, watch my video boundaries. It's a high conflict child custody video, and I talk about this unreasonable request of hers with regards to the cell phones and all that. This is just a tremendous amount of work for such a small thing. Education arrangements we're going to stipulate, medical arrangements, as long as it doesn't subvert the court's order regarding modification, and this has to do with my ex's neglectful behavior in the past on medical stuff. Attorney fees. I'm opposing any agreement on attorney fee awards. Parties can proceed to request an attorney fee award under the vehicles described in Rivero 2009 and Rule 11, as well as 18.020 subsection 2b. Transportation costs. What is this about? Oh, okay. So it needs to. What I'm asking for is some kind of limit on my ex's transportation costs. I'm saying this because she can just financially annihilate both of us, and she would have if she could have. And you guys will find this out when we end up going to the hearing, and you find out how much money she's spending on these trips, and the judge blows up on her because, I mean, you know what? The hearing video will speak for itself. You'll see. Tax exemptions and credits. By the way, guys, we have a hearing video coming up. I think it's 5 videos from now in the My Docket series. So somewhere around, I think, 174 of the My Docket series, we should be having another premiere and another hearing video. Extracurriculars. Guys, what I'm talking about here in this portion of my suggestion, or the compromise, I guess you could call it, is already discussed in the video extracurriculars. Please watch my video on the topic extracurriculars because pages and pages are spent on this. We'll talk about it more when the final order is entered as well. Emergency situations, future disputes. Yeah, this is a pretty good case that I cite here. City of Reno versus Silver State Flying Service. Which, I mean, it's, how do you really, you can't agree to agree. I mean, you don't know what's going to happen in the future, so an agreement to agree is essentially nothing. The courts don't treat it as anything. Modification. I oppose compulsory mediation. Okay, I see. So this, I meant to type mediation here, not modification. Existing court rules control when mediation is appropriate. I consistently oppose mediation under Rule 53. It's pretty crazy that my attorney went along with this. She did warn me that she thought the judge was not going to order this, but she was wrong. The judge did order this. Mediation is one of those things that sounds really, really flowery and nice and happy-go-lucky, and so attorneys are hesitant to argue against it because they don't want to look bad. And it's a total waste of time in this case, and I wish more judges would be open to the fact that mediation is pointless with high conflict exes. Governing law and venue. I'm not sure what this is talking about. The UCCJEA should control this, so I don't know why. I mean, we're even having to talk about that. Rule 5, certificate of service indicating this document was mailed to my ex. Okay, here we have the list of exhibits. Parenting. Okay, so this is the compromise parenting plan that I was talking about, guys. I'm going to skip over this completely for the reasons mentioned in this video. Email message. So we got a bunch of emails and letters, it looks like, between my attorney and my ex's attorney. So exhibit 1 is the proposed compromise parenting plan. It's going to look the exact same way that the parenting plan did, with the exception of the, I guess you could say, objections to the various provisions. So certain provisions will be changed based on what I stated in that prior document. So, for example, if I objected to a provision, it would be removed from the compromise, and if I had like a alternative suggested, then it would reflect that alternative. But we're going to spend plenty of time going through the actual final parenting plan that was entered by the judge. This email looks to be dealing with medical stuff. medical, educational. I think it's silly that attorneys have to talk this stuff out. I mean, I understand why they do it. I guess they're just used to having to do it now. And I mean, in my opinion, as a judge, seeing this kind of stuff as a judge that the parents can't even work out it would make me want to pinpoint who the problem is and deprive them of custody. It's not appropriate for judges to be making attorneys have to work through this stuff for their clients. It's ridiculous. Yet this is another thing here. We're dealing with appointments and such. Like, attorneys are sending each other, or at least it's my attorney sending her attorney these details on these appointments. I don't even think her attorney's responding to anything. We have yet another message. This one has to do with money. So more bills have popped up, it looks like. Oh, okay. So this is over the arrearages that my ex owes. And she's asking the attorney to have her issue a check in this amount of money immediately. Okay, she's referencing a letter requesting... Okay, so this is over the $50 that my ex tried to pay that we sent back because it's an unreasonable thing to do with all those thousands of dollars ordered. Send a $50 payment late and then expect us to not execute. Talked about that already. We're going to go through that through the series as the appeal ends up reversing and all that. Yet another email to her attorney complaining that the amount received was not enough. A letter to her attorney, and this is over new expenses. Okay, so I mentioned this earlier, and I was right. There are new expenses. So more dental visits have occurred and more expenses have been incurred. Here's the bill for the new charges that I'm assuming my ex didn't pay again. Exhibit 5. Here is... Okay, so this is the email on my new job and my intent to move to Las Vegas. And that's it. Next document. Order to set hearing. This is the judge indicating that we need to appear at a setting and actually set the date for the hearing itself. If you guys want to know the distinction between setting a hearing and setting a date to set the hearing, please watch the video Notice to Set, because that's what's going on here. Indicating this is a certificate of service indicating that this order was sent to both my attorney and my ex's attorney. Application for setting. So this means that the attorneys, both attorneys for myself and my ex, appeared and set the day for a trial. And it looks like it's June 29th, 2015, and it's half a day. So I would assume that's a 4-hour hearing. Maybe it's 3.5 if you count lunches or something. I don't know. Okay. Going into the aftermath, I filed one document, but it was a free filing, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. My attorney isn't charging me, so I incurred $0 in attorney fees. My ex's attorney would have had to review a response. Would have probably taken 15 to 30 minutes. I'm going to lean in the direction of 30 minutes because it was a pretty detailed response, and it's highly relevant. It comes up at the hearing. The attorney would have had to read through it to really know what our position was. So a half an hour is reasonable. And I think preparing for an appearing at the setting, because he's gonna have to dial in, he's gonna have to spend time on the phone, he's gonna have to pick the dates and times. So I think another 15 minutes, no, let's say 30 minutes. 30 minutes there is reasonable, so that's a total of an hour, and attorney fees for my ex at the rate of $250 an hour comes to $250 in attorney fees for my ex. As on previous videos, if you have any questions, feel free to post those down in the comments below, and I will see you guys next time.